Throughout the collective bargaining process, management and labor representatives determine the terms and conditions of their ongoing relationship. The collective bargaining process involved in negotiating a contract consists of 4 possible stages: preparation and initial demands, negotiations, settlement or impasse, and strikes and lockouts. In preparation and initial demands, each side presents its list of demands to the other to begin the bargaining process. If the organization argues it cannot afford to pay what the union is asking, then it must provide evidence of its financial status. The primary focus of bargaining for both the union and management is on mandatory issues of bargaining, like wages, benefits, and working hours and other conditions. After taking initial positions, each side attempts to determine what the other side values highly so that the best bargain can be struck. Provisions in federal law require the employer and the union bargaining representatives negotiate in good faith. In good faith negotiations, the parties agree to send negotiators who can bargain and make decisions, rather than people who do not have the authority to commit either group to a decision. To be more effective, meetings between the parties should be conducted professionally and address issues rather than being confrontational. Refusing to bargain, scheduling meetings at absurdly inconvenient hours, and/or using other conflicting tactics may lead to employers or unions filing complaints with the NLRB. After reaching an initial agreement, the bargaining parties usually return to their respective constituencies to determine if the informal agreement is acceptable. A particularly crucial stage is ratification of the labor agreement, which is a process by which union members vote to accept the terms of a negotiated labor agreement. Before ratification, the union negotiating team explains the agreement to the union members and presents it for a vote. Regardless of the structure of the bargaining process, labor and management do not always reach agreement on the issues. If they reach an impasse, then disputes can be taken to conciliation, mediation, or arbitration. When an impasse occurs, an outside party, such as the Federal Mediation and Conciliation Service, may help the two deadlocked parties continue negotiations and arrive at a solution. In mediation, the third party suggests ideas for solution to help the negotiators reach a settlement. The third party does not impose a solution. Sometimes, fact-finding helps clarify the issues of disagreement as an intermediate step between mediation and arbitration. In arbitration, a neutral third party makes a decision. Arbitration can be conducted by an individual or a panel of individuals. Interest arbitration attempts to solve bargaining impasses, primarily in the public sector. This type of arbitration is uncommon in private sector because companies generally do not want an outside party making decisions about their rights, wages, benefits, and other issues. Fortunately, in many situations, agreements are reached through negotiations without the need for arbitration. When disagreements continue, strikes or lockouts may occur. The collective bargaining process includes preparation and initial demands, negotiation, and settlement of contract agreement.